We'll be taking you through the introductory segment of our presentation today. The focus of our webinar will touch and concern the following areas, namely, who are we at the OPR, objectives of the Act, what are challenge proceedings, who hears and determines challenge proceedings, what are the governing laws and rules for challenge proceedings, what can be challenged, what are the time frames for submitting an application for review, the standstill period, the 20-day process for challenge proceedings, things to remember, and can the decision of the hearing panel be appealed? Okay, so let's begin. Who are we at the OPR? The Office of Procurement Regulation is a body corporate established pursuant to the Public Procurement and Disposal of Public Property Act number 1 of 2015 as amended. There were 3 amendments to the Act. The first was in 2016, the second in 2017, and the third in 2020. The Act aims to provide for public procurement and for the retention and disposal of public property. Please note that pursuant to Section 13, subsection 2B of the Act, the Office, in exercising its functions, shall not be subject to the direction or control of any other person or authority in the performance of its functions, but it shall be accountable to Parliament. Let's now move on to the objectives of the Act. So pursuant to Section 5.1, the objectives of the Act are to promote A, the principles of accountability, integrity, transparency, and value for money. B, efficiency, fairness, equity, and public confidence. And C, local industry development, sustainable procurement, and sustainable development in public procurement and the disposal of public property. So one of the mechanisms built into the Act for carrying out these objectives is the challenge process. And with all the discussion surrounding the Act in general and the fact that persons can bring challenge proceedings, let's explore what are challenge proceedings. Challenge proceedings is a process by which a supplier or contractor who is the applicant may apply to the office for a review of a decision or action taken by a procuring entity who is the respondent in a procurement proceeding. Pursuant to Section 49(1) of the Act, a supplier or contractor may bring challenge proceedings where it is alleged that A, a procuring entity made a decision or took an action that is not in compliance with this Act, and B, the supplier or contractor has suffered or is likely to suffer loss or injury because of the decision or action of the procuring entity. Please note the use of the word "and" in order to bring a challenge against the decision of the procuring entity. The supplier or contractor must satisfy both A and B. So now that you understand what are challenge proceedings, let us now look at who hears and determines these proceedings. So the office has established a hearing tribunal to hear and determine challenge proceedings. The hearing panels will comprise of members of the board and management of the office, of no less than 3 and no more than 5, who are selected by the office for their competence in the specific areas of disputes. And one of these members will be appointed to chair the hearing. In order to resolve the challenge applications brought before the tribunal, and in keeping with the objectives of the Act, all concerned should be aware of and abide by the governing laws and rules for challenge proceedings. And these governing laws and rules are Part 5 of the Public Procurement and Disposal of Public Property Act, number 1 of 2015 as amended, the Public Procurement and Disposal of Public Property Challenge Proceedings Regulations 2021, the hearing rules and procedure for Part 5 challenge proceedings, and the electronic filing and hearing rules for Part 5 challenge proceedings. The Act and the regulations can be found on our website, and the hearing rules and electronic hearing rules will be uploaded soon. Okay, so let's find out now who can initiate challenge proceedings. A supplier or contractor who has suffered or is likely to suffer loss or injury because of the decision or action taken by a procuring entity in procurement proceedings, which are not in compliance with the Act, can initiate the process. To do so, the supplier or contractor must submit an application for review to the office, further to Section 50, subsection 1 of the Act. And when making the application, one would be required to outline the basis of the challenge. So let's now look at what can be challenged. As stated earlier, suppliers or contractors can challenge decisions or actions taken by a procuring entity in procurement proceedings that are not in compliance with the Act. As such, challenges can relate to 4 particular circumstances, namely, 1, the terms of pre-qualification or decisions or actions taken in pre-qualification proceedings. So, for example, a failure to respond to a supplier's request for clarification of the pre-qualification documentation within a reasonable time to enable the supplier to present an application in a timely manner. 2, the terms of pre-selection or decisions or actions taken in pre-selection proceedings. For example, where a maximum number of contractors to participate in a procurement activity is specified, and the supplier is not listed without proper justification, or the maximum number is exceeded. The third circumstance relates to terms of solicitation. For example, the terms of reference or specification favors one supplier, product, or brand. And fourthly, other decisions or actions taken in a procurement proceeding. For instance, accepting late bids without proper justification and without notifying the other bidders. Please note that these challenges must be filed before the time frame specified in Section 50, subsection 2 of the Act. So what are these time frames? In the first 3 circumstances mentioned in the previous slide, where the challenge relates to the terms of pre-qualification, pre-selection or solicitation, or the decisions or actions taken by a procuring entity in pre-qualification or pre-selection proceedings, the deadline to file this challenge is before the deadline for presenting submissions. Where, however, the challenge relates to other decisions or actions taken by a procuring entity in procurement proceedings, the deadline to file this challenge depends on whether or not a standstill period was applied by the procuring entity. So if a standstill period was applied, the deadline to file this challenge is within the standstill period. If, however, a standstill period was not applied, the deadline to file this challenge is within 7 working days after the publication of the notice of decision or action that was taken by the procuring entity. I know some of you may be wondering what exactly is the standstill period, so let's find out. This diagram illustrates the standstill period process. The standstill period is a short pause of 10 to 15 working days in duration, which begins when the notice of decision or award is issued to participating suppliers or contractors. In the procurement cycle, the standstill period occurs before issuing the notice of acceptance to the successful bidder. And according to Section 35, subsection 2 of the Act, a procuring entity shall promptly notify each supplier or contractor who presented submissions of its decision to accept the successful submission at the end of the standstill period. The duration of the standstill period is calculated based on the form of communication the procuring entity intends to use to transmit the standstill notice to the suppliers or contractors. A 10-day standstill period is to be used if the notice is to be dispatched via email, and 15 days where the notice will be sent via mail, letter, or reliable courier. The standstill period begins at 1 minute after midnight on the day of dispatch of the notification of decision to award and ends at midnight on either the 10th working day after the notice is communicated electronically or the 15th working day from the date of sending the notice via letter, mail, or reliable courier. In this particular example, the standstill duration is 10 working days, which is the minimum requirement of the Public Procurement and Disposal of Public Property Evaluation Regulations 2021. So if no challenges are made within the 10-day period in this example, then the procuring entity is free to award the contract or framework agreements. If an application for review or challenge is received by the office, however, this would initiate challenge proceedings. So thank you everyone for your attention thus far, and I will now hand you over to Ms. Tamara Maharajh to continue with our presentation today.
Thank you, Ms. Sinanan. I will now take us through the challenge proceedings process at the office, which starts from the moment an application for review is submitted and ends when the final decision is made by the hearing panel. As you can see, it is referred to as the 20-day process. This is because Section 50, subsection 11 of the Act stipulates that the decision of the office shall be issued within 20 working days after receipt of the application for review. The office then has 30 working days to provide written reasons for its decision in accordance with Section 50, subsection 12 of the Act. As we will continue to see in the following slides, there are steps to be taken by the parties and the office each day of the process in order to achieve completion and decision by day 20. The office will therefore be constrained to maintain the timelines in this process, and requests for extensions of time at various junctures may rarely be accommodated. On the days not specifically highlighted, the office will be conducting its internal preparations for the hearing or other deliberations to determine the matter by day 20. So let's turn to the first 3 days of the process. We will be focusing on the areas which procuring entities should take note of as they navigate the process before the office. So day 1 of the challenge proceedings process begins with the submission of an application for review to the office by an applicant. As Ms. Sinanan indicated earlier, an applicant is a supplier or contractor who participates in the procurement proceedings that are being conducted by a procuring entity and satisfies the requirements of Section 49 of the Act. In terms of the procedural aspects of the documents and communications involved during the challenge process, in an effort to maintain simplicity and uniformity, the office has created prescribed forms which are to be used throughout the proceedings. So, for example, the application for review is Form 8. Additionally, the office has created an email platform to receive submissions by the parties upon proclamation of the Act. This email address is challenge@opr.org.tt, and it will be the medium through which the OPR officer, who is designated as the hearing secretary, will communicate with the parties and vice versa. When a document is submitted through the email platform, the hearing secretary will subsequently email a stamped copy of that document to the party that submitted it. This indicates that the document has been filed, and the stamped document has to be served on the other parties to the proceedings. So once an application for review is received on day 1, the office will take the following steps within the first 3 days. It will publish a notice of the application in 2 daily newspapers and on its website, and it will notify the procuring entity of the application for review via email to the accounting officer or equivalent and the named procurement officer. For this reason, it is of utmost importance that procuring entities provide up-to-date information on the names and email addresses of these office holders and promptly notify us of any changes. So turning now to days 4 to 6, as shown in the slide, there are 4 main activities highlighted during this period. These relate to suspension, dismissal, the reply, and applications to participate. Let's first look at the issue of suspension. Section 50, subsection 4 of the Act empowers the office to suspend either the procurement proceedings before entry into force of the procurement contract or the performance of a procurement contract or operation of a framework agreement that has entered into force. The office can determine the length of the suspension for as long as it finds necessary to protect the interests of the applicant. This power of suspension may be exercised by the office within 3 days of receipt of the application for review. The office will notify the parties of its decision on suspension between days 4 and 5. Reasons for this decision will be provided by day 7. This is in accordance with sections 50, subsection 6, and subsection 7 of the Act. The second area highlighted in this slide is the issue of dismissal of the application for review. Regulation 4 empowers the office to dismiss an application for review and lift any suspension that is in effect in 3 circumstances, namely, where the office is of the opinion that the application is manifestly without merit, or where it was not presented in compliance with the timeline set out in section 50, subsection 2 of the Act. And thirdly, where the applicant has not demonstrated sufficient standing by way of either pecuniary or otherwise economic interest in the proceeding. Where the office exercises its power to dismiss an application in those circumstances, it will promptly notify the applicant, the procuring entity, and all qualified suppliers and contractors in the procurement proceedings of the dismissal with reason. The third and most important activity from the perspective of the procuring entity during this period of the 20-day process is the submission of the reply. Under Regulation 9(1), within 3 working days of the receipt of the notification that an application for review was submitted to the office, the respondent must submit a written reply and documentary evidence in support of the office. Transcribing this time frame into the 20-day process, it means that the latest day for the submission of the reply and supporting documents to the office is day 6. We will go into the details of the reply and supporting documents in the next 2 slides, but there are two things that are to be highlighted at this point. Firstly, a party can engage a representative to act on its behalf during the challenge proceedings. A representative can be an attorney at law or such other suitably qualified and experienced person, which may include, but is not limited to, an engineer, quantity surveyor, valuator, agent, or such person as shall be recognized by the office for the purpose of representation in accordance with Regulation 7. Where a representative is engaged, Form 2, notice of appointment of a representative, must be filed with the office and served on the other parties. The second point to note is that under Regulation 9.5, the respondent may request that the office authorize it to award a procurement contract or enter into a framework agreement on the grounds that a delay in the award of the procurement contract or entering the framework agreement would be contrary to the public interest, or such other consideration which would justify the award of the procurement contract or entering the framework agreement while the office conducts its review. Where the respondents request such authorization, the grounds being relied upon must be substantiated by evidence in support and be provided to the office for its consideration of the request. This request may be submitted to the office at the time of the respondent's written reply. The fourth activity during days 4 to 6 to be aware of is that interested parties can apply to participate in ongoing proceedings. This is done through the submission of Form 10, an application to participate, and it is to be done by day 6. An interested party is someone who falls in the categories set out in Section 51, subsection 1 of the Act. That is, any supplier, contractor who participates in procurement proceedings to which the application for review relates, or any public body whose interests are or could be affected by the application for review. So this is a snapshot of what the Form 9 reply looks like. As stated earlier, the forms will be posted on the OPR's website, so you can download and familiarize yourself with the information provided. We will look now at some of the key details of this form. The key information to be filled out by the respondent in Form 9, the reply is as follows. The email address of the named procurement officer, and if a representative is retained, that person's email and contact details. Secondly, the reply to the facts concerning the decision or actions being reviewed. This section gives the respondent the opportunity to state the pertinent background facts and matters about the procurement proceedings and the decision or action that the applicant is challenging. Verification or other response to the information provided by the applicant, and particular sections of the Form 8 application for review. So, for example, the respondent has to indicate whether the applicant accurately stated the tender number, date of issuance of the solicitation document, deadline set by the respondent for presenting submissions in response to the solicitation documents, or the length of the standstill period if one was applied. If the information provided by the applicant is inaccurate, the respondent has an opportunity to indicate the correct information and attach the relevant document in support. Fourthly, the respondent has an opportunity in the reply to respond to each and every ground of review for each decision or action that is being challenged by the applicant, which he would have outlined in his Form 8 application for review. The respondent must also state any facts or matters which are relevant to the release or remedies sought by the applicant. The names of all the persons the respondent intends to call as witnesses at the hearing in support of the facts and matters stated in the reply must also be listed. The effort taken to resolve the issue directly with the applicant must also be outlined. The office encourages parties to dialogue before the matter is escalated to the point of the filing of an application for review. The issue may easily be resolved, for example, where there's a simple mathematical error in the tallying of evaluation scores, and engaging in dialogue can avoid the initiation of challenge proceedings and the consequential costs and delay in the procurement process. Procuring entities are therefore encouraged to respond to any requests for clarification or complaints submitted by suppliers or contractors. Once this is done, details of dialogue can be provided and attached to the Form 9 reply if the matter is escalated to the office. Finally, it is important to note that the Form 9 reply must be signed by the accounting officer or its equivalent, as stipulated in Regulation 9(1)A. As a point of note, the office has prepared instructional guides on how to complete all the prescribed forms to assist parties, and these will be uploaded to the website shortly. Turning to the documents to be provided in support, the Form 9 reply lists the following examples of information that can be attached, depending on their relevance to the matters raised in the application for review. These supporting documents include invitation to bid, request for proposal or quotation, invitation for pre-qualification or pre-selection, notice of intention of award issued by the respondent, bid submitted by the applicant, request for clarification received from the applicant, correspondence between the applicant and the respondent in relation to efforts taken to resolve the issue directly with the respondent, and any emails, correspondence, or other documents which are relevant to the decision or action being challenged. Note that not only are these supporting documents to be listed in the body of Form 9, but copies must be attached to the reply. Failure to attach any relevant documents can result in the inability of the respondent to rely on these at the hearing. Furthermore, Regulation 9(1)C stipulates the respondent must submit any other document referred to in the application for review, which is in its possession but not available to the applicant. It should be noted that Form 9 allows redaction of information relating to categories set out in Section 52 of the Act. This is information which, if disclosed, would A, impair the protection of essential security interests of the state, B, be contrary to law, C, impede law enforcement, D, prejudice the legitimate commercial interests of suppliers or contractors, or E, impede fair competition. The office intends to issue guidelines on how redaction pursuant to Section 52 should be undertaken. So we can see how much information is required from the respondent from very early in the process. This front-end loading, so to speak, is to enable the office to be appraised of all the material facts and matters as early as possible so that the challenge process can be completed within the statutorily imposed 20-day deadline. This slide demonstrates what actions the office's hearing panel can take if the respondent fails to submit a reply. If there is no good cause for failing to submit a reply, Regulation 9(4) states that the office may proceed with its deliberations on the basis of the evidence before it, as if such proceedings had been conducted in the presence of all parties. This means that the office can make decisions requiring certain actions it considers appropriate in the circumstances to be taken, and the respondent shall be bound by any decision of the office. So we know that a lot of content is being shared as we go through the 20-day process. We will now pause for a 10-minute break at this juncture, and when we resume, we will look at what happens from day 8 onwards. So thank you for rejoining our sensitization session on challenge proceedings. As we continue with the 20-day process, we now turn to days 8 and 9. During this period, the office will provide the parties with the following. Firstly, a notice of case management conference, which will state the following key information. So the first thing to be indicated on this notice for case management conference would be the date, time, place, and purpose of the CMC. Whether the parties are required to attend in person, that they may be represented by a representative, but the person must have the authority to make agreements and give undertakings on behalf of the party at the CMC. That if the party does not attend, either themselves or through a representative, the presiding member of the hearing panel may proceed in their absence. And finally, that binding orders would be made by the hearing panel with respect to the continued conduct of the challenge proceedings. Secondly, if the respondent requested authorization to award a procurement contract or enter into a framework agreement, the decision on this request would be provided. Thirdly, if an interested party submitted an application to participate, the decision on this application would also be provided, as well as decisions on any other applications which were previously filed. It is to be noted that if a party seeks to have an expert provide evidence at the hearing in support of their case, an application for leave or permission to call this expert evidence must be filed between days 8 and 9. So let's turn now to this area of expert evidence. This is a snapshot of Form 11, the application for leave to call expert evidence. We will now look at some of the key details to be provided in this form. The first point to note is that a party must first seek the permission or leave of the hearing panel to call or adduce expert evidence at the hearing. Expert evidence must be reasonably required to resolve the challenge proceedings justly and in accordance with the overriding objective of the hearing rules and procedures for challenge proceedings. The overriding objective is to enable the hearing panel to deal with cases fairly and justly, having regard to various considerations, including dealing with the case in ways which are proportionate to the importance of the case, the complexity of the issues, the anticipated costs, and the resources of the parties, and avoiding delay so far as is compatible with proper consideration of the issues to be determined in the challenge proceedings. The Form 11 application for leave to call expert evidence must include details such as the name, address, and qualifications of the proposed expert, issues on which the expert will provide evidence, the substance or summary of the relevant points of the expert's evidence, list of documents to which the expert will refer, the grounds for the application for leave to call this expert witness. Day 11 is the scheduled day for the case management conference on the matter. At this conference, the hearing panel can make orders with respect to the conduct of challenge proceedings after giving the parties an opportunity to make representations. Some examples of these orders relate to the simplification or clarification of issues, disclosure of documents, facts or evidence that may be agreed upon, preliminary matters, skeleton submissions, the scheduling of the hearing date, and resolution of any or all of the issues in challenge proceedings. By day 11, parties must also inform the office if any of the following situations applies. Firstly, if the assistance of an interpreter is required, this is to be done by submitting a Form 6 Notice of Requirement of an Interpreter. It should be noted that arrangements to retain and utilize the services of an interpreter is to be borne by the party submitting the notification to the office. Secondly, if accommodation is required for differently abled persons to attend the hearing, Form 7 Notice of Requirement of Accommodation must be submitted by day 11. Between days 12 and 13, the office will provide the notice of the directions or order that were made at the CMC, as well as provide the date, time, and place of the hearing to all parties. The party requiring the assistance of an interpreter must submit the qualifications of the chosen interpreter to the office during this period. And finally, all parties must file and serve their respective witness statements, expert evidence if applicable, and skeleton submissions. Let's take a look at the details to be provided in witness statements. From the perspective of the respondent, the witness statement must provide an account of the facts in support of the claims stated in the reply. It can refer to and attach any relevant supporting documents. However, note that those documents must have been attached to the Form 9 reply at the beginning of the proceedings. The witness statement must also include a statement that the matters set out are within the witness's own knowledge, except where otherwise indicated, and that the contents are true and correct. And finally, it must be signed and dated by the witness. A party who fails to provide a witness statement in accordance with the hearing rules and procedures for challenge proceedings may not call that person as a witness without the leave of the hearing panel. Where expert evidence is allowed by the hearing panel, the expert witness must provide independent assistance to the hearing panel by way of objective, unbiased opinion in relation to the matters within his expertise, and he must follow the guidelines contained at Schedule 1 of the Hearing Rules and Procedures for Challenge Proceedings. Some of these guidelines are that an expert witness must not change his opinion or withhold information to suit the position taken by the party that has retained or employed him, and that the expert has certain duties of disclosure, such as the responsibility to make fair and full disclosure, making it clear when a particular question or issue falls outside of his or her area of expertise, and where the opinion and evidence are based on information contained in other documents, detailed references should be provided in any report prepared by the experts, and copies of those documents must be attached to his report. Turning to skeleton submissions now. These are a summary of the arguments in support of the responses in the reply in relation to the allegations that the respondent made a decision or took an action that is not in compliance with the Act, and when the applicant has suffered or is likely to suffer loss or injury because of the decision or action of the procuring entity. In essence, skeleton submissions provide the framework for the oral closing submissions of the respondent at the hearing. Now, then 14 is not highlighted in this slide as the procuring entity is not required to file any documents at this point, but all parties and the hearing panel will be preparing for days 15 to 16, which is the hearing of the application for review. Some points to note now about the hearing. All parties are required to attend. Non-attendance by a party will not prevent the hearing panel from continuing with the hearing in that party's absence, where it is satisfied that the notification of the hearing was received and the party is absent without good cause. At the hearing, the applicant will present its case and call witnesses who can be questioned by the other parties and the hearing panel. The respondent and interested parties, if any, will follow the same process. Each party will then be given an opportunity to make oral closing submissions to the hearing panel. It should be noted that the hearing is the latest time at which the applicant can make an application for course Form 15 in accordance with the hearing rules. If such an application is made, the respondent will be given an opportunity to make representations on same. After the hearing, the panel will meet between days 17 and 19 to deliberate on the evidence provided. It will formulate its decision by day 20, as stipulated under Section 50, subsection 11 of the Act. And immediately thereafter, it will communicate its decision to all parties and other participants in the procurement proceedings. All persons shall comply with the decision and directive of the office. Written reasons will be provided no later than 30 days after the decision in accordance with Section 50, subsection 12 of the Act. If the procurement proceedings were suspended, this order suspension shall be lifted immediately upon the issuance of the decision of the hearing panel on day 20. By day 30, parties can apply for the record of the hearing via Form 16, and this record will be in an electronic format. So this brings us to the end of the 20-day challenge proceedings process. Turning to a few things to remember as you go through the entire process. Firstly, every application will be assigned a specific case reference number upon the initiation of the proceedings. That is, when the applicant submits his application for review, the office will issue an email indicating the case reference number assigned. The email the office sends to the accounting officer or equivalent and NPO informing of the filing of the application for review will state the case reference number. This number must be stated at the beginning of the subject line in all emails or correspondence that is submitted to the office thereafter, and it must also be included in any other forms filed with the office. The number must be reproduced in the identical format issued, that is, without any spaces or characters in between. Secondly, once documents are stamped as being filed, the office will email them to the filing party, who must then serve these stamped documents on the other parties to the proceedings. When this service is done, a confirmation of service Form 1 must be submitted to the office. Where there was personal service, a copy of the endorsed document must be attached. This is the copy where the person receiving the file document signs and dates the first page, showing that the original was received. Where there was electronic service, a copy of the email showing the electronically delivered document must also be attached. Also note that documents submitted to the office for filing must be emailed between the hours of 8 a.m. and 4 p.m. on working days. Where documents are sent outside this prescribed time without the permission of the hearing panel, the sender will receive an email from the office stating that his email will be returned and must be filed within working hours on working days. If documents are submitted on public holidays, the filing date will be stamped as the next business day. So you would recall that during the 20-day challenge proceedings process before the office, a decision can be issued relating to the suspension of the procurement proceedings by day 3. And then the final decision on the substantive matter will be issued by day 20. If a party is dissatisfied with and has an interest in any of these orders or decisions, he can appeal to the Public Procurement Review Board by requesting a review of the decision of the office. This review mechanism is provided for under sections 51A to L of the Act. A request for review to the review board must be made within 21 days of receiving the order or decision of the OPR's hearing panel. The review board may dismiss a request for review that it believes is frivolous or vexatious. Within 21 days of receiving the request, the review board must meet to conduct a review, and that review process must be completed within 28 days. The review board can take two broad forms of actions upon completion of its review. It can confirm, vary, or overturn the decision of the hearing panel, and it can order the payment of costs as between the parties to the review. If a party still feels aggrieved at this stage, they can subsequently appeal against the decision of the review board to the High Court within 28 days of the making of the decision. So this now brings us to the end of the formal presentation of the challenge proceedings process before the OPR and the appeal mechanisms thereafter as contained in the Act. I thank you for your attention and will now hand you over to Ms. Tamara Roy to continue our webinar.